Yesterday, January 24th, 2026, federal agents shot and killed a 51-year-old man on a Minneapolis street. Videos show agents firing multiple shots into a man as he lay on the ground. This is the third shooting by federal agents in Minneapolis in 18 days. The first killed Renee Good, a 37-year-old mother of three, shot through her car window. 3,000 armed federal agents have been deployed to Minneapolis against the explicit objections of the governor, the mayor, and the community they claim to serve. The governor of Minnesota says this is, quote, sickening, unquote. The mayor of Minneapolis has told federal agents to, quote, get the fuck out, unquote. And today, we're going to answer the question you're asking. What can we actually do when the enforcers become the violators? When people convicted of sedition are running the show and those defending the Constitution are accused of obstruction? This is Ethos Trek. I'm Sarah, and this episode is not about outrage, although you may hear it in my voice. It's about frameworks. It's about resistance. The constitutional reality. Let's start with what's actually happening legally. The chain of command problem. The Department of Homeland Security is not part of the Department of Defense. ICE and CBP are civilian law enforcement agencies with specific, limited statutory authority under immigration law. What's happening in Minneapolis? Thousands of armed federal agents in tactical gear conducting military-style operations against the explicit objections of state and local government exceeds that statutory authority. This matters because of something called the ultra vires doctrine. Ultra vires is Latin for beyond the powers. When a government agency acts outside the legal scope of its authority, those actions are, by definition, not the lawful acts of the United States government. The Legal Information Institute at Cornell defines it this way. When a government body exceeds its proper scope of power, that action is ultra vires, and the Constitution is the measuring stick. The Supreme Court has repeatedly affirmed this principle. In Youngstown Sheet and Tube Company versus Sawyer in 1952, the court held that presidential authority, quote, must stem from either an act of Congress or from the Constitution itself, unquote. President Truman's seizure of steel mills was struck down because it exceeded his constitutional authority. Today, the Administrative Procedure Act, Section 706, Paragraph 2, Subparagraph C, gives courts jurisdiction to, quote, hold unlawful and set aside agency action found to be in excess of statutory jurisdiction, authority, or limitations, unquote. Why does this matter for Minneapolis? Because ICE's statutory authority is immigration enforcement, not suppressing protests, not conducting military-style occupations of American cities, not shooting unarmed civilians, and not operating in direct defiance of state police powers. The 10th Amendment and Federalism. The 10th Amendment reserves to the states all powers not delegated to the federal government. This includes police powers, the authority to protect public safety within state borders. What's happening in Minneapolis is a direct assault on this principle. Minnesota's Attorney General has filed suit arguing that, quote, DHS agents have essentially commandeered police resources in Minnesota by forcing state and local law enforcement agents to clean up the chaos that DHS agents have caused, unquote. By January 9th, Minneapolis police had worked more than 3,000 hours of overtime, over $2 million in taxpayer costs, responding to the federal incursion. Schools have gone into lockdown. Businesses have closed. Customer-facing businesses report revenue drops of 50 to 80%. This is not immigration enforcement. This is occupation, and the Constitution has something to say about that. The sedition paradox. Now let's address the elephant in the room. Seditious conspiracy, 18 U.S.C. subsection 2384, requires conspiracy to, quote, overthrow, put down, or destroy by force the government of the United States, unquote, or, quote, by force to prevent, hinder, or delay the execution of any law of the United States, unquote. 9 members of the Oath Keepers were convicted of seditious conspiracy for January 6th. Stuart Rhodes received 18 years. Kelly Meggs received 12 years. These individuals were pardoned. Meanwhile, Governor Tim Walz and Mayor Jacob Frey are now under DOJ investigation for allegedly, quote, obstructing, unquote, federal operations by publicly criticizing them. Let that sink in. The people who violently attacked the Capitol to overturn an election are free. The officials defending their communities against armed federal agents who have killed 3 people are under investigation. Here's the critical legal distinction. Sedition requires opposing lawful authority. If federal agents are acting outside their constitutional and statutory authority, if they are operating ultra vires, then resistance isn't sedition. It's defense of constitutional order. You cannot, quote unquote, obstruct an unlawful act. Ready for some critical thinking questions? Question 1. What distinguishes constitutional resistance from sedition? The key is the word lawful. If a governor instructs state officials not to assist federal agents in conducting warrantless arrests, that's not obstruction. That's the anti-commandeering doctrine established by the Supreme Court. If citizens document federal agents' activities and share that information, that's not sedition. That's the First Amendment. If communities organize mutual aid to support people targeted by unlawful raids, that's not conspiracy. That's civil society functioning as intended. The accusation of sedition is a political weapon, but it has legal elements that must be met. Those elements require opposing lawful authority by force. Peaceful resistance, non-cooperation, and documentation do not meet that standard. Question 2. What happens when the enforcement mechanism is the violator? This is the fundamental constitutional inversion we're facing. The Constitution is not self-enforcing. It relies on institutions, courts, legislators, executives, to give it meaning and power. When those institutions are captured by people who view the Constitution as an obstacle rather than a mandate, the document itself becomes vulnerable. But the Constitution also anticipated this problem. The framers built in redundancy, separation of powers, federalism, and ultimately, the people themselves. James Madison wrote in Federalist 46 about states serving as a check on federal overreach. He advised, quote, refusal to cooperate with officers of the Union, unquote, as a legitimate form of resistance. This is not a fringe theory. This is foundational constitutional design. What are the historical precedents? This is not unprecedented. We've been here before. After the Fugitive Slave Act of 1793, northern states faced a choice: assist in the capture and return of enslaved people, or refuse. Many refused. In Prigg v. Pennsylvania, in 1842, the Supreme Court established what we now call the anti-commandeering doctrine. Justice Joseph Story held that while federal law was supreme, the federal government could not force states to implement or carry out federal law. States could forbid their officials from cooperating. This precedent has been affirmed repeatedly. New York v. United States in 1992, Congress cannot compel states to enact or enforce federal regulatory programs. Prince v. United States in 1997, the federal government cannot command state officers to administer federal programs. Murphy v. NC2A in 2018, anti-commandeering applies broadly to federal attempts to control state policy. The federal government may enforce its own laws with its own resources. It cannot conscript states into doing so. Act. Here's a framework for resistance. This is the part you need. What can you actually do? I'm going to break this down by actor. States, individuals, organizations, and international observers. For states, legal tools. 1. Anti-commandeering. States can and should instruct state and local officials not to assist federal immigration enforcement. This is constitutionally protected. Minnesota is already doing this. 2. State civil rights enforcement. State attorneys general can investigate and prosecute federal agents who violate state civil rights laws. Killing an unarmed civilian is not immunized simply because the shooter wears a federal badge, especially when acting ultra vires. 3. Targeted injunctive relief. File for injunctions on specific unconstitutional conduct. Judge Menendez's ruling demonstrates this works. She barred federal agents from using pepper spray on peaceful protesters, from retaliating against observers, and from conducting pretextual traffic stops. 4. Interstate compacts. States can form agreements for mutual aid, shared legal defense, and economic coordination. Article 1, Section 10 permits interstate compacts with congressional consent, and many compacts operate without explicit consent when they don't increase state power at federal expense. Administrative actions. 1. Revoke state facility access. States control state buildings, jails, and infrastructure. Federal agents have no automatic right to use state resources. 2. Withdraw data sharing. Many states share law enforcement databases with federal agencies. That sharing is discretionary. 3. Regulate licensing. Federal agents operating vehicles on state roads are subject to state traffic laws. States can enforce those laws. Economic leverage. The economic blackout in Minneapolis, businesses closed, workers staying home, demonstrates that states and localities have economic power. Federal operations are not costless, and communities can impose costs in return. For individuals, know your rights. 1. You have the right to observe and document federal agents. This is protected First Amendment activity. Judge Menendez affirmed this explicitly. 2. You have the right to remain silent. You do not have to answer questions about your immigration status, where you were born, or where you are going. You can say, quote, I am exercising my right to remain silent, unquote. 3. You have the right to refuse consent to search. Without a warrant signed by a judge, you can refuse to allow agents into your home. Say, quote, I do not consent to a search, unquote. 4. You have the right to an attorney. If detained, say, quote, I want to speak with a lawyer before answering any questions, unquote. Documentation practices. 1. Film everything. Bystander video has been crucial in exposing what's happening in Minneapolis. The video of Renee Good's death. The video of shots fired into a man on the ground. Film at a safe distance. Keep filming, even if you're told to stop. You have that right in public spaces. 2. Live stream when possible. Live video cannot be deleted. It creates a real-time record. 3. Back up immediately. Upload to cloud storage. Send to trusted contacts. Do not assume your device will remain in your possession. 4. Report to legal observers. The ACLU and the National Lawyers Guild maintain legal observer networks. Report incidents to them. Community networks. 1. Rapid response networks. When ICE is spotted, communities can alert each other. This is legal. Information sharing is protected speech. 2. Know your rights training. Host or attend trainings so your community knows how to respond if approached by federal agents. 3. Sanctuary support. Help neighbors develop safety plans. Know who in your community may be targeted and check on them. What not to do? I have to be direct about this, and I really want you to hear this. Do not physically interfere with federal agents. Do not physically interfere with federal agents. 1. They're dangerous as fuck. 2. This can be charged as a federal crime and will be used to justify escalation. The administration wants violent confrontation. That's the pretext for invoking the Insurrection Act. Do not make threats. Do not damage federal property. Do not provide any justification for the narrative that resistance is terrorism. The most powerful resistance is disciplined, documented, and constitutionally grounded. That is what they cannot defeat. For organizations, legal support. 1. Fund and support lawsuits. The ACLU lawsuit, the state lawsuit, the municipal lawsuit. These are all battlegrounds where constitutional limits will be enforced or abandoned. 2. Deploy legal observers. Trained observers documenting agent conduct create records for litigation and accountability. 3. Provide representation. People detained need lawyers. Habeas corpus still exists. Challenge every unlawful detention. Mutual aid. 1. Support affected families. When a breadwinner is detained, families need immediate support. Rent, food, childcare. 2. Bond funds. Immigration bonds can be thousands of dollars. Bond funds help people get out of detention while fighting their cases. 3. Accompaniment programs. Trained volunteers can accompany people to court dates, ICE check-ins, and other interactions where having a witness matters. Coalition building. This is not only an immigration rights issue. This is a constitutional crisis issue. The ACLU lawsuit includes U.S. citizens who were detained. Renee Good was a U.S. citizen. The precedents being set affect everyone. Build coalitions that reflect that reality. Civil liberties organizations, faith communities, labor unions, racial justice groups, veterans organizations, and constitutional conservatives who take federalism seriously. For international observers, when domestic legal systems fail, international frameworks become relevant. Human rights documentation. The International Covenant on Civil and Political Rights, which the United States ratified in 1992, guarantees the right to life, freedom from arbitrary detention, and the right to peaceful assembly. While the U.S. has limited direct enforcement of the ICCPR in domestic courts, documentation matters for UN Human Rights Committee periodic reviews, Inter-American Commission on Human Rights petitions, International Criminal Court consideration for crimes against humanity which require systematic or widespread attacks on civilian populations. What international observers can do? 1. Document systematically. Human rights organizations should treat Minneapolis as a documentation priority. 2. Submit shadow reports. NGOs can submit reports to UN treaty bodies detailing U.S. violations of ratified treaties. 3. Petitions to regional bodies. The Inter-American Commission on Human Rights accepts individual petitions alleging violations by OAS member states. 4. Diplomatic pressure. Other governments can and should raise concerns through diplomatic channels about the treatment of their nationals and the broader human rights situation. Why this matters? Even if international mechanisms cannot directly stop what's happening, they create a record. They establish that the international community witnessed what occurred. They make future accountability possible. History will judge not only the perpetrators, but those who watched in silence. I want to step back for just a moment. What we're witnessing in Minneapolis is not an aberration. It is the implementation of a deliberate strategy to expand executive power, weaken federalism, and create a climate of fear that suppresses democratic participation. The Heritage Foundation's Project 2025 explicitly called for expanding immigration enforcement powers and deploying them aggressively in quote-unquote sanctuary jurisdictions. What's happening is not improvisation. It's a playbook being executed. But here's what they didn't anticipate. Resistance that is grounded in the Constitution itself. The anti-commandeering doctrine comes from a conservative legal tradition. Federalism is not a progressive value. It's a structural protection that cuts across ideological lines. The Fourth Amendment prohibition on unreasonable searches and seizures is not partisan. The First Amendment protection of assembly and speech is not partisan. When we ground our resistance in these principles, we occupy constitutional high ground. We make clear that we're not opposing America, we are defending it. And that is a framework they cannot defeat through force alone. Here's what I'd like you to take away from this episode. 1. The Constitution still matters, but only if we use it. The tools exist. Anti-commandeering, ultra vires challenges, civil rights litigation, First Amendment protection. They only work if states, individuals, and organizations deploy them. 2. Documentation is resistance. Every video, every report, every record creates accountability. Film, share, archive. 3. Discipline is power. The administration wants violent confrontation. Deny them that pretext. The most devastating resistance is peaceful, persistent, and impossible to dismiss as lawless. 4. This is everyone's fight. Today it's Minneapolis. Today it's the Somali community. But the precedents being set reach everyone. Constitutional limits either hold or they don't. I'll have a companion article on Substack with full citations to every case, statute, and source mentioned in this episode. I'll also have a downloadable action guide you can share with your community, your elected officials, and your networks. If you hear anyone say, "But what can I do?" or "What can we do?" please forward this video or give them the action guide. Because analysis paralysis is the enemy of democracy. This is Ethos Trek. I'm Sarah. Thank you for thinking with me.